Hello everyone, I am Dhriti Dhairya and here am I with a fresh lecture series on the subject The Code of Criminal Procedure 1973. So before moving on to this particular subject, I would like to thank you for all the love, appreciation, the request for other subjects and all the positive feedback that you have given me for the CPC lecture series. I really hope that lecture series is helping you, even the notes are helping you, and I hope that this particular lecture series also helps you in the same manner. And in case you haven't watched that lecture series, I would be attaching a link to the playlist of that lecture series in the description box of this video. So before we start on with today's subject, there are some pointers that I want to tell you. Firstly, there's a reason why I chose criminal procedure as the next subject to follow up CPC. The reason was that because now you are sort of accustomed to the way I deal with procedural law, so it would be easier to see how we are using that same approach for criminal procedure. So this was the first reason why I chose this subject. Now, secondly, the way I deal with procedural laws, now you're quite familiar also, and the framework in this particular course will also be similar to the CPC course. Obviously, there is a marked distinction between the two subjects. CPC does has orders and sections. Here, they are only sections, so that distinction obviously will be there. And the third thing that I want to say here is that there'll be just one difference between that lecture series and this. One major difference that will be there is that here I might not be uploading a limited number of videos. The number of videos might increase than that what was there in the CPC series. Here the videos, however, will get shorter. So my main approach with the CPC series was that I wanted to keep only a limited number of videos, and I was not caring about the length of the videos. Because I felt that the number of videos should not exceed and make it a daunting process that okay, for CPC now you have to watch so many videos. So but here I feel with criminal procedure we can like flip the approach and we can have shorter videos and more videos. Like in case you feel that the old approach was better, please let me know, we can go back to that. But for starters, we'll start off with this approach of smaller and more videos. So let's now start with today's subject, that is the Code of Criminal Procedure 1973. So as you remember, when we were studying CPC, we had followed the same pattern. I had given you an introduction that for reading any act, bare act, etc., first see what is the date of enactment and the date of enforcement. Here you'll see that the date of enactment is 25th 1, 1974. Date of enforcement is 1/4/1974. Now, when you have seen the date of enactment and the date of enforcement, the next logical thing that we need to see is where does this act apply to? So the first thing we see is that it applies to the whole of India, except, so there are two exceptions. First is the state of Jammu Kashmir. This is as is written in the Bare Act. Now, obviously, you know, because of the changed status of Article 370, this is not true. However, the next one is important, that is, it does not apply to Nagaland and the tribal areas. However, there are three chapters, that is 8, 10, and 11, that does apply, even though it is in the exception part. For the rest of the CPC, the state government can notify and ensure that how they want the applicability to be there. So you've seen the date of enactment, enforcement, and the extent. Now, what do we see next? So now we understood, okay, these are the important dates, and we have seen where it is extending. The next thing we see is what was the need for bringing this act? What was the object? If you can remember in CPC, then it was a consolidating and an amending act. CrPC is also a consolidating and amending act. You can see the usage of the word code. When we are using the word code, we are trying to show that all the laws which are relating to criminal procedure, we are trying to bring it under one umbrella as much as possible. What amendments were needed from the previous legislations of criminal procedure, that is being done, and it is again a consolidating and an amending act. Like what are we doing? We are trying to bring in one place whatever the procedure should be that will govern the courts of criminal judicature. Now, next thing we see better now, because now we have brought all these rules, regulations, laws, sections together, then whether is it exhaustive or not. So whatever is written in CrPC, whatever matters are covered in CrPC, in respect of that, the code is exhaustive, but not otherwise. So what will happen where it is not mentioned? If you can remember in CPC that the court was having an inherent power, here also there is an inherent power, that is 482, which the circumstances have not been dealt with. Then the court here, however, you have to remember this court here is only the power of the High Court. Why they can use the inherent powers? To give effect to an order passed under the court, or to prevent the abuse of court, or to secure the ends of justice. This you might have to remember because there may be a contrast between section 151 CPC and section 482 of CRPC. One distinction, CPC you were seeing what? That it was a power of any civil code. Here you are seeing it is a power of only the High Court. And then you have to other point that you have to see is what are the purposes for which you will use this inherent powers. Under 482 it is to give effect to an order under the court, prevent abuse of any court, and secure the ends of justice. And in the same manner, you can see under 151 what has been written. So this is what is the object of the code. Now, how are we using this code? So obviously, you know that CPC is a procedural law, it is an objective law. So what is it trying to do? It is looking after the process of administration and enforcement of substantial criminal law. Like that, you know, the substantial criminal law, what, like IPC has identified certain offenses, given down punishments. How will you identify, how will you ensure that, okay, whenever such an act or omission is committed which is a crime by a particular legislation, then how would we proceed forward with it? How will we find the offender, punish the offender? All that is being dealt under CRPC. Now, why is CRPC now important? Because IPC is now giving you a threat of punishment, that, oh look, if you commit theft, then this is the punishment that will be awarded to you. But what is CRPC doing in this place? It is ensuring that this threat is not hollow. It is ensuring that this threat is carried out. In case you actually do this task, it is not just that in the paper it is written that you'll be punished with such and such imprisonment, but in reality there are courts that will go in function and will impose such a punishment on you. So this is the importance of CRPC. Now, what is it also helping you to do? It is helping to maintain the rule of law. It is helping to maintain that rule of law in a society. It is the more used law in comparison to CPC, if you see. Why? Because it affects a greater number of people. It is affecting human values also to a greater extent. So how the provisions have to be designed, in what manner will you arrest somebody, what manner will you pass summons, order, warrants, etc., that becomes of utmost importance, because CPC does not touch so much on the human values as much as the criminal procedure does. Here you are actually curtailing liberty of a person. Here you are trying to provide justice to a person who has suffered a loss that cannot be measured by any amount of compensation, etc. So this, and not only that, apart from that, in this particular code also has to see that no undue justice is done, that just because a person has been put under suspicion of being an accused, we cannot just go and convict him. You also have to see that he gets a fair trial. So a delicate balance between the accused and the victim, the powers and the liabilities of the officers, and other aspects of the codes have been dealt in the various provision of the code. So I hope you could understand what are we trying to do with this code. Now, obviously, there have been a quite number of amendments in this code also. When you are reading amendments from the exam point of view, please read the enactment and the enforcement dates. You can see the main provisions also. Like this is quite a popular question in the mains aspect, etc. Like give the overview of the 2013 amendment in respect of CRPC. So you'll write for these are the particular amendments in respect of women offenses, women related offenses, how the recording of statements provisions have been changed, what is the need for a women officer, all that things you have to see. So you can go back and see the amendments also. I don't want to increase the length unnecessarily, so I am not dealing with amendments here. You can, but you should, and you should go and deal with the amendments in brief also. If you want, you can also deal with history of CRPC, so but it is not that much as important as we had seen in the CPC side. Now, after this, what we are seeing, that what is the scope of applicability of this code. So now we are seeing that what are the laws which would be covered, what are the offenses under the various laws where this procedure will be applied. So section 4 is saying that whatever offenses are there under IPC and the other laws, if it is IPC, the investigation, inquiry and trial will be done according to CRPC. For other laws where there are any offenses, investigation, inquiry and trial will be done with respect of CRPC only, but it will be subject to any other enactment in respect of the same. Like if a particular act is talking about, like for example, dowry provision also has makes certain acts criminal offenses. There, unless there is something specifically written that no, this procedure under CRPC will not be applicable, till then CRPC will apply. But if there are special provisions that you have to follow because of that act, that provisions also you need to follow. Then what does section 5 say? Section 5 says, unless specifically stated, CRPC provisions do not affect special or local laws or any special jurisdiction or power which has been conferred or any special procedure that has been prescribed. So for example, we are saying here that CRPC is a general law, and what we know, if there is a special law or if there is a local law, the special or the local law takes precedent. And just because there is a clash between the two procedures doesn't mean that that procedure is bad. CRPC's provision won't affect it. For example, the Juvenile Justice Act, a special procedure has been defined, and this would be the court identify all of that things. There, the special procedure prescribed there will prevail over CRPC. I hope now this was the introduction part to CRPC. I hope you are clear with it. What did we see here was that we saw the date of enforcement, we saw the date of enactment, we saw the extent, we saw the object of it being a consolidating and amending act, we saw a bit about section 482, we contrasted it with section 151 of CPC also, we saw how this code is being used, what is the use of this code. Then I asked you to go back and see the amendments also. Recent amendments are also there. You have to see that. And what is the scope of applicability of the code? You have to see sections 4 and 5. So let's start now with definitions. Now definitions, if you are remembering for CPC or even if you don't remember from the CPC lecture, definitions I would request and recommend that please go through all of them and read bare act. Here section numbers become very important. Section 2A mein kya hai, section 2C mein kya hai, all of that becomes really important because prelims, a lot of states do ask that section 2C defines what, section 2W defines what. So for that I said please do go through the definitions. So we'll start with the first definition, that is section 2A. Section 2A talks about bailable and non-bailable offense. Bailable offense is what offense? An offense which has been shown bailable in the first schedule is taken as a bailable offense, and an offense which is taken as non-bailable, which has been stated as non-bailable in the first schedule, is a non-bailable offense. Simply that in that offense where you do not have a right to bail. Where you do not have a right to bail. If it is do not have a right to bail, then it is a non-bailable offense. A bailable offense, you have a right to bail. That is the first type of offenses or cases that you can say. Then the second is 2C, where we are talking about cognizable offense and case. And with that, we'll also read section 2L, which talks about non-cognizable offense and case. So what is the cognizable thing here? If it is a cognizable offense or a case, here the police officer has a right to arrest you without getting a warrant from the magistrate. And where will it be written that which offense is cognizable or not? It will be written in the first schedule or in any other law. And non-cognizable, here the police cannot arrest you without any warrant. This was the second distinction. Let's move on to the next distinction, that is section 2.4, that is summons case. So how has it been defined? That is a case relating to an offense which is not a warrant case. So for that we need to know what is a warrant case. That is section 2X, that is a warrant case. Those cases which are punishable with an imprisonment exceeding 2 years or more. Like for simple statement, if you want to remember, 2 years or more, it is a warrant case. Though when you see the proper definition, it is if it is an offense which is punishable with death, life imprisonment, or an imprisonment exceeding 2 years. So if it is less than 2 years, it automatically becomes a summons case. Now next what we will see is 2B, charge. Now what does charge include? A charge includes any head of charge when charge contains more than one. I know this definition seems a little absurd, but when we'll go into the details of what is charge, there you'll be able to understand why such a definition has been given. This is the reason why I'm not elaborating here, because I want to correlate these definitions when we actually cover the topics. But here, just to form an introductory base, we are going through the definitions. Then we see section 2D, that is complaint. Now what is a complaint? Here you have to remember there is an allegation which is either orally or in writing made to whom? To a magistrate. That for what purpose? That please take action under the court that some person, either known or unknown, has committed an offense, and this complaint does not include a police report. Now, however, if there is a report of a police officer after he has investigated, it is disclosing that there is a non-cognizable offense was there, then that report of the police officer will be deemed as a complaint and the police officer will be taken as a complainant. So you see, a complainant is coming in what kind of cases? It is coming in the mostly in the kind of cases where it is a non-cognizable offense. So what did we see? It is an allegation orally or in writing to a magistrate to take action under the code that person unknown or known has committed an offense but does not include a police report. Now what do we see? The next type of thing is 2G, that is inquiry. Every inquiry other than a trial which is conducted by a magistrate or a court. So what are we seeing? A magistrate or a court can do two things. It can also do a trial and also an inquiry, and both of them are separate. So other than a trial, whatever inquiry is conducted by a court or a magistrate will be taken as an inquiry. And what is investigation? Investigation are all the proceedings that you're doing under this code for what? For the purpose of collecting evidence, and it is done by whom? The police officer or any other person other than a magistrate who is authorized by a magistrate in its behalf. So what distinction that you're seeing? An inquiry is done by a magistrate or a court, and an investigation is done by a police officer. You see the distinction here, right? Then we are seeing section 2I, which deals with judicial proceeding. Now, judicial proceeding includes every proceeding in course of which evidence is taken or may be taken on oath. Then we see section 2N, that is offense. What is an offense? It is an act or omission which is made punishable by any law in time being enforced. And what does it include? It also includes a complaint that can be made under section 20 of the Cattle Trespass Act 1871. You have to remember this, that this is an including offense also includes a particular section number of the Cattle Trespass Act. Then you see to section 2O. Section 2O is talking about officer in charge of a police station. Who is an officer in charge of a police station? So firstly, it is an officer who is in charge of the police station, and secondly, if that particular officer is absent from the station house, or he is ill, or he cannot perform his duties, then whichever officer is present at that time at the station house and is next in rank to the person in charge, officer in charge of the police station, and is above the rank of the constable or any other officer as the state government's directs, can be taken as an officer in charge of a police station. Then section 2R is telling about a police report. What is a police report? It is a report forwarded by a police officer under sections 173. The next definition we are seeing is section 2WA, which was inserted by the 2008 Amendment Act, which defines a victim. Who is a victim? A person who has suffered loss or injury caused by loss or act or omission for which an accused person has been charged. And this victim will also include the victim's guardian or legal heir. For example, that person is now dead, then the legal heir, etc., can be taken under as a victim for this particular code. And section 2O is what? It is defining the public prosecutor. A public prosecutor is a person appointed under section 24 and includes all other persons who act under the directions of the public prosecutor. And then section 2Y is sort of telling you that whatever words and expressions that are being used in the code but have not been defined here, but in case they have been defined in the IPC, then they will have the same meanings as they have in IPC. Also next, you can see sections 2E, which defines High Court, India, local jurisdiction, metropolitan area, notification, place, pleader, prescribed, and subdivision. So this was all about the definitions. Let's see what would we cover in definitions. The first thing that we covered was 2A, bailable and non-bailable offense. You remember where there is a right of bail, there is not right of bail, and it is mentioned in the first schedule in that manner. Secondly, we saw 2C and 2L, cognizable offense and non-cognizable offense and case, where we saw if it is cognizable, then the police officer can arrest without warrant. Non-cognizable, cannot arrest without warrant. The next distinction we were seeing was about summons case and warrants case, 2W and 2X. Warrant case, more than 2 years, then warrant, less than that, then summons. Obviously, more than 2 years plus life imprisonment or death, you have to also remember that. Then we saw 2B, charge, that if there's a head of charge and it contains more than one, then that will also be included. Then we saw what is a complaint, where you are making an allegation directly or orally to a magistrate. does not include a police report. Here you can see what is a police report. That was we had read under 2R, that it is a report forwarded by a police officer to a magistrate under section 173(2). Then you can see what is an inquiry. Remember, inquiry is always by a magistrate or a court. Trial is also by a magistrate or a court. Investigation, however, is only by the police. There the court or the magistrate will not enter. The moment they enter, then it becomes an inquiry and not investigation. Okay, that is 2G, 2H, 2I judicial proceeding, where the evidence is or may be taken on oath. Then we saw what is the definition of an offense under 2N, and 2O, that is officer in charge of a police station. We also saw section 2WA that defines victim, where a person has suffered loss or injury caused by act or omission for which the accused person has been charged. It also includes the victim's guardian or legal heir. Then you saw the definition of a public prosecutor, and 2Y, that whatever has not been defined here but is in the IPC, you can bring those meanings here too, and the rest of the definitions you can see. I hope this is clear. And just one small tip for remembering the section numbers here. In the code of criminal procedure, you'll see that it is all of them are in alphabetical order. So for example, if I'm trying to recall that, okay, for bailable offense is what is the section number, was it A or B or whatever, I'll try and remember that whether anything with A was mentioned or not, then I'll get, okay, it was 2A bailable offense. Then suddenly then we'll see that what would be whether complaint is 2B or 2D. So I'll try and see that, okay, the words that might have been defined in criminal procedure are charge, complaint, cognizable offense. So alphabetically I'll arrange and then I might get it. So you can remember it in an alphabetical order, and especially in MCQs, you'll be able to guess by that means also. So this is it for the first lecture. I know it is short because as I already told you, we are changing the mode of the lectures from this particular lecture series. But I hope it was short and crisp and you were able to grasp it. I know we did not deal into a lot of depth about the definitions, but don't worry, we will be going into depth when we'll be studying the related topics. So this is it for today. I hope you liked the lecture. Please leave your feedback and comments, and do let me know if you like this mode of lectures better. Thank you.